What are the major events in the Chapter 13 bankruptcy process, and when will the bankruptcy be over? At Cox Law Group, all of our bankruptcies start with the same thing, a consultation with an attorney. So at that attorney, if we determine with you that a Chapter 13 is the best option for you, we'll then lay out a course for you for how we'll get that case filed. Often that will depend upon a number of documents and other information that we need you to provide, and it will often require one or two or several more appointments before we can file the case. One of the most important appointments is what we call the signing appointment, and that is when you return to review and sign your petition in detail. At that time, you may need to spend at least an hour, maybe two, at our office as we go over those pages with you from your petition. You'll have the opportunity, of course, to talk to the attorney and review those documents with he or she to make sure that they're as accurate as possible. Then the case is filed with the court. That's another important milestone, if you will, in the process. Once the case is filed, all creditors have to cease collection activity, and you'll get a case number. At that time, the court also determines or schedules a meeting of creditors. You'll have to attend that meeting of creditors, and that's somewhere between 3 to 6 months after the case is filed. At that time, we'll sit down with the trustee and make sure that the plan makes sense to the trustee and address any concerns that he or she might have. Then a confirmation hearing is set to confirm or approve the plan that we've proposed in your case. Sometimes those plans are approved at the first confirmation hearing, and sometimes it takes a few hearings. As a general rule, you don't need to attend those hearings, but you'll want to ask your attorney to be sure. In some cases, there might be an unusual objection or a particular reason that you'll need to be in court for one of those hearings. Once the case is approved or confirmed by the court, it just becomes administered by the trustee, and the trustee makes the payments that are required under the plan. Once you've paid out all payments required under the plan, you're issued a discharge in your case. Remember, you have to start making your payments to the trustee as soon as the case is filed. You don't wait for the plan to be approved. And also remember, you have to take what's called a debt education course before your case can actually be concluded. All of this information we'll go over with you during the time that you're in the case, and of course you can always ask us questions. We're always available at Cox Law Group.